Hello viewers, today we will be dealing with the chapter Introduction to International Environmental Law. As the genesis of environment is international in nature, we will be dealing with various international conferences that have emerged in the sphere of environment. First, let us deal with the introduction. Under growing pressure from national and international public opinion, governments began to demonstrate concern over the general state of the environment during the 1960s and introduced legislation to combat pollution of inland waters, ocean and air, and to safeguard certain cities or areas. Simultaneously, they established special administrative organs, ministries, or environmental agencies to preserve more effectively the quality of life of their citizens. Developments in international environmental law parallel this evolution within states, reflecting a growing consensus to accord priority to resolving environmental problems. Let us deal with the sources of international environmental law. The international community has developed its own system of creating norms and making international laws. These are basically twofold: treaties and customary international law. Treaties can only be binding on those that consent to them. They are solemn binding agreements between subjects of the international legal order. International customary law is defined by the Statute of the International Court of Justice as general practice accepted as law by states. Treaties and custom constitute rigid, not so flexible law, and this law is followed by the nation states under the threat of sanction from the international legal system and community. Another category of law is termed soft law and is comprised of non-binding instruments that lay down guidelines for future action. Soft law is largely based on international diplomacy and customs, dependent on good faith or fear of diplomatic retribution. The 1972 Stockholm Declaration and the 1992 Rio Declaration, which embody a series of widely revered environmental principles, constitute good examples of soft law. Ancillary sources of international law also exist, such as doctrines, judicial decisions, General Assembly resolutions, and opinions of international jurists. In order to understand the international environmental regime, it is necessary to understand certain important conferences and conventions which have been instrumental in developing environmental law worldwide. First, let us deal with the International Convention for the Protection of Birds, 1950. Realizing the danger of extinction of certain species of birds and numerical decrease in migratory species, this convention was adopted on 18/12/1950 at Paris, France, to protect the birds in their natural habitat. The major objective is to provide for general protection to be given to all the birds during the breeding season, to migrants during their flight to their breeding grounds, and to endangered species throughout. Parties are supposed to take measures to prevent destruction of birds by water pollution, electric cables, insecticides, and poisons, and to create awareness among people towards protection of birds. The parties are supposed to establish reserves for breeding birds. Next is the Convention on Wetlands of International Importance, especially as Waterfowl Habitat 1971 Ramsar Convention. This convention is an intergovernmental treaty adopted on 2 of 1971 in the Iranian city of Ramsar. This is the first of the modern global intergovernmental treaties on conservation and wide use of natural resources. The convention aims to cover all aspects of wetland conservation and wise use, recognizing wetlands as ecosystems that are extremely important for biodiversity conservation and for the well-being of human communities. The summary of these provisions is: each party shall designate and conserve suitable wetlands within its territory for inclusion in the list of wetlands of international importance through nature reserves. Wetlands are among the world's most productive environments. They are cradles of biological diversity, providing water and primary productivity upon which countless species of plants and animals depend for their survival. Wetlands are also important storehouses of plant genetic materials. These lands also provide tremendous economic benefit. Now let us deal with the genesis of environmental law, the United Nations Conference on Human Environment, Stockholm, 1972. The UN Conference on Human Environment, held at Stockholm from June 5th to June 16th, 1972, rightly been reckoned as the first major step to solve the global problem of conservation and regulation of human environment by international agreement on an universal level. The main contributions of the Stockholm Conference of 1972, Human Environment, comprises of the Declaration of Human Environment. The declaration is divided into two parts. First part proclaims 7 truths about man in relation to his environment, and part 2 enumerates 26 principles. The action plan for human environment, it is divided into 3 parts: framework for environment action, recommendations for action at the international level, and the action plan. The resolution on industrial and financial arrangements. It recommended the establishment of following institutions and financial arrangements, which are the Governing Council for Environmental Programs, UNEP, Environmental Secretariat, Environmental Fund, and an Environment Coordination Board. The Constitution of United Nations Environment Program. United Nations Environment Program was established in 1972 by General Assembly Resolution 2997 following the Stockholm Conference, and it has played a significant catalytic role in the development of treaties and soft law rules. It is based in Nairobi and comprised of a governing council of 58 members, elected by the General Assembly, and an Environment Secretariat headed by the United Nations Environment Program Executive Director. Following United Nations Conference on Environment and Development and World Summit on Sustainable Development, it remains the only United Nations body exclusively dedicated to international environmental cooperation to provide policy guidance for the direction and coordination of environmental programs within the United Nations system. The resolution on designation of a World Environment Day, its recommendation that June 5th be observed as World Environment Day was eventually adopted by the General Assembly of the UN through a resolution. Resolution on nuclear weapons tests. It recommended nuclear tests, especially those carried out in the atmosphere, and called upon states to refrain from conducting such tests as it would contaminate the environment. Next is the Convention on International Trade in Endangered Species of Wild Fauna and Flora. This convention was adopted on 3rd March 1973 at Washington to protect certain species of wild fauna and flora against overexploitation through international trade. Next is the Convention on the Conservation of Migratory Species of Wild Animals, Bonn Convention. This convention was adopted on 23 June 1979 at Bonn, Germany, and came into force on 1/11/1983 to protect those species of wildlife that migrate across or outside national boundaries. The convention aimed at international agreements which would deal with the conservation and management of the migratory species concerned. The Nairobi Declaration 1982. The 10th anniversary of the 1972 Stockholm Conference was celebrated in Nairobi from 10th to 18th May 1982 by the world community. A follow-up to the Stockholm Conference was held in 1982 in Nairobi, which spurred the United Nations to set up the World Commission on Environment and Development, chaired by Gro Harlem Brundtland, then Prime Minister of Norway. Its 1987 report, Our Common Future, placed the concept of sustainable development into the realm of international environmental law. Vienna Convention for the Protection of the Ozone Layer, 1985. The problem of stratospheric ozone layer was identified in the year 1981 with the commencement of intergovernmental negotiations for an international agreement to phase out ozone depleting substances in 1985. It succeeded in establishing a mechanism for international cooperation and laid down the framework for a legally binding future protocol to control ozone depleting substances. The provisions made at the Vienna Convention are given below. Montreal Protocol required that each party shall ban the import of CFC 11, CFC 12, CFC 113, CFC 114, CFC 115, CF2 BRCL, CF3BR, C2F4BR from any state not party to this protocol by 1/1/1990. According to United Nations Environment Programme, the Montreal Protocol has resulted in a significant decrease in the production and use of CFCs. In 1986, global consumption of CFCs was about 1.1 million tons, which decreased to 0.146 million tons by 1997. It is estimated that in the absence of Montreal Protocol, the global CFCs consumption would have increased to 3 million tons by 2010 and 8 million tons by 2060, which by 2035 would have depleted the ozone layer by 50%. The Basel Convention. The Convention on the Control of Transboundary Movements of Hazardous Waste and Their Disposal was signed in Basel, Switzerland on March 22, 1989. The Basel Convention is built around two basic principles: proper waste management and prior informed consent. Another important conference, Rio Conference. The UN-CED conference held 20 years after the Stockholm Conference was popularly perceived as an attempt at environmental planning on a grand scale. In addition to a tremendous surge in environmental consciousness, The Rio summit resulted in Agenda 21, an action plan for the next 10 years and into the 21st century. The Rio Declaration on the Environment and Development, the 1992 United Nations Framework Convention on Climate Change to control the emissions of greenhouse gases, particularly carbon dioxide and deforestation. The 1992 Convention on Biological Diversity for the purpose of dealing with the problem of extinction of species and providing safeguard measures for the endangered species. The non-legally binding authoritative statement on forests. The United Nations Framework Convention on Climate Change. This convention was adopted to regulate and reduce levels of greenhouse gases concentration in the atmosphere, so as to avoid the series of climatic changes on the level that would hinder sustainable economic development at UNCED at Rio de Janeiro in June 1992. This came into force on 21 May 1994. The ultimate objective of the convention is to achieve stabilization of greenhouse gases concentration in the atmosphere at a level that would prevent dangerous anthropogenic interference with the climate within a reasonable time. The main provisions of the convention are: parties would prepare national inventories on greenhouse gases emissions and on action taken to remove them, formulate and implement programs for the control of climate change, undertake education and training policies that would enhance public awareness relating to climate change. The developed countries who are parties to the convention would commit themselves to take special measures to limit anthropogenic emissions of greenhouse gases at 1990 levels by 2000 and to enhance the capacity of their sinks and reservoirs for stabilizing such gases. The developed countries who are parties to the convention would undertake to accord financial support to developing countries to develop and to enable the latter to comply with the terms of the convention. Sustainable development. The concept is defined by the 1987 Brundtland Committee report as development that meets the needs of the present without compromising the ability of future generations to meet their own needs. This principle is at the heart of many environmental initiatives. It recognizes the need for intergenerational equity, sustainable and equitable use of resources held in common by the current generation and the integration of environmental considerations into economic and other development initiatives. This principle is also reflected in the Framework Convention on Climate Change in Article 3, Clause 4, among others. The next important convention is the Convention on Biological Diversity. The Convention on Biological Diversity was one of the two agreements signed at the United Nations Conference on Environment and Development held in Rio de Janeiro, Brazil from June 3, 1992. The agreement was unique in that its objective was to protect all species and ecosystems in the world as opposed to specified endangered species. The objectives are the conservation of biological diversity, the sustainable use of its components, and the fair and equitable sharing of the benefits arising out of the utilization of genetic resources. There were many biodiversity conferences to achieve the goal set up in the Rio conference. Out of them, COP11 is significant as it was the 11th meeting of the Conference of the Parties to the Convention on Biological Diversity 2012, and it was held in Hyderabad. India COP11 adopted 33 decisions on a range of strategic, substantive, administrative, financial and budgetary issues. Among other issues, the meeting addressed the status of the Nagoya Protocol on access to genetic resources and benefit sharing, implementation of the strategic plan 2011 to 2020 and progress towards the Aichi biodiversity targets and implementation of the strategy for resource mobilization. The 12th meeting of the Conference of the Parties to the Convention on Biological Diversity held from 6 to 17 October 2014 at Pyeongchang, Republic of Korea. COP12 includes an agreement on the Pyeongchang roadmap containing 5 decisions on mid-term review of progress towards the goals of the 2011 to 2020 strategic plan for biodiversity and the Aichi targets, biodiversity and sustainable development, review of progress in providing support in implementing the objectives of the convention, cooperation with other conventions and a strategy for resource mobilization. The International Environmental Protection Doctrines and Concepts. Several principles of international environmental policy, some earlier enunciated in the Stockholm Declaration, were crystallized through the Rio process. Among them were the precautionary principle, polluter pays principle, sustainable development, common but differentiated responsibility and environment impact assessment. Common but differentiated responsibility. Articulated as Principle 7 of the Rio Declaration, this principle requires states to cooperate in a spirit of global partnership to protect the environment. States have contributed differently to global environmental problems. The principle recognizes that they should have common but differentiated responsibilities. The Kyoto Protocol. To govern the principle of common but differentiated responsibility is highly significant. The structure of the 1997 United Nations Framework Convention on Climate Change, Kyoto Protocol, mirrors the philosophy of common but differentiated responsibility. Developed countries are committed to reducing their overall emissions of greenhouse gases by at least 5% below 1990 levels between 2008 and 2012. Although every nation state has the responsibility to reduce global greenhouse gas emissions, only Organization for Economic Cooperation and Development and economies in transition countries are required to make specific quantified emission limitation. There were many climate change conferences after United Nations Framework Convention on Climate Change almost every year to curb carbon emissions, but a strong consensus was not reached between the countries. A new 2015 agreement on climate change that will harness action by all nations took a further important step forward in Lima following 2 weeks of negotiations by over 190 countries. Nations participated by agreeing the ground rules on how all countries can submit contributions to the new agreement during the first quarter of next year. The further process scheduled to be agreed in Paris in late 2015. Polluter pays principle, precautionary principle, doctrine of public trust and environmental impact assessment are some of the relevant doctrines and concepts relating to environmental protection. The next conference was the World Summit at Johannesburg. UNCED received its first major review at the World Summit on Sustainable Development in Johannesburg in the year 2002. The main outcomes relating to the institutional framework to support sustainable development were recommendations to adopt new measures to strengthen institutional arrangements for sustainable development at international, regional and national levels. Facilitate and promote the integration of the environmental, social and economic dimensions of sustainable development into the work programs of United Regional Commissions. Enhance the role of the Commission on Sustainable Development, including through reviewing and monitoring progress in the implementation of Agenda 21. I would like to conclude by saying that during the 3 decades since the emergence of ecological degradation as an issue of great global concern, environmental law has been the primary mechanism used to promote natural resources conservation, pollution control and other forms of environmental protection. The realm of international environmental law has grown to encompass hundreds of international and regional treaties, thousands of national laws, and countless administrative regulations promulgated by more than 180 states and multilateral organizations such as the United Nations agencies. By all measures of states and diplomatic and legal activity, the field of international environmental law has experienced remarkable growth. Dear viewers, today we have dealt with the chapter Introduction to International Environmental Law, being the genesis of all the environmental laws in the world. In the next chapters to come, we will be dealing with specific regulations and laws prevailing to India and protection towards environment protection. Thank you.